also, in just to make sure that the record's clear, based on our arguments, based on the fact that we argued the evidence was insufficient, we should be granted a directed verdict that we object to instructing the jury at all with respect to tampering, physical evidence, or murder. And I will be happy to submit it at this point. Okay.
And let me also say that on the facilitation instruction that the defense has tendered, having looked at KRS 506.080, I do not believe that there has been any evidence produced at trial to support the giving of a criminal facilitation instruction. Okay, anything else we need to take up before we adjourn?
Your Honor, I would ask to take up the issue of the admonition.
Okay.
I did make a copy of the discovery with respect to Mr. Gowker's polygraph examination. If I may approach the bench, I can give you a copy.
Yes.
I think that Ms. Smith pointed out to the court that Gowker was taken to do a polygraph examination. You can see what the examiner noted. He was unable to render a decision based on insufficient chart data. The venue was poor due to noise, and the examinee requested numerous smoke breaks during the test. So, trying to figure out how to cure that. It's hard to unring the bell. Gowker said he took a polygraph test, and I'm trying to remember which witness. One of the snitches said that Gowker told him that he passed the test. So we're fearful that the jury may spend time thinking about that. I told the court that we've been waiting a long time to go to trial. We didn't want to miss trial. Under normal circumstances, when polygraph comes up, we'd ask for a mistrial. We didn't ask for it, but we would like to try to remedy it without having a mistrial. So if there's a way we can give an admonition, I don't know if the Commonwealth would agree that Gowker did not complete the polygraph. It appears because of the breaks and that sort of thing that he really didn't. It was an incomplete examination. If we could agree to stipulate that. I know that we've closed the testimony. That might be a possibility. Otherwise, I would ask the court to admonish the jury that any testimony the jury may have heard concerning the polygraph examination taken by Joshua Gowker shall not be considered by you for any reason. You must give that testimony no weight. Something to that effect. Deal with the fact that that's out there. I know we can't unring the bell, but I think there's a real danger they may wonder if Gowker passed the test or not. The fact that it was spoken by him. So that would be my request too. If we can't get an agreement that the test was incomplete, which I would interpret this as incomplete because of Gowker's smoke break, so there was not enough information. I don't know if we could agree to that we didn't have a complete result, or again in the alternative, admonish the jury not to consider it. Thank you.
Thank you. Response from the Commonwealth.
Thank you, Your Honor. We would object to any admonition about the polygraph. Obviously, the jury's memory will be the jury's memory of what the testimony was is the most important, and I could certainly be incorrect, but I don't believe that Gowker actually testified about the polygraph. I believe the only mention of it was from the inmate Bierman, who stated that Gowker bragged to him that he had passed or fooled the polygraph. That is the only evidence in my memory that has been put before the court. Obviously, the Commonwealth had no intention of eliciting that. It was volunteered by that witness. The Commonwealth does not believe it's proper to provide any testimony or evidence about polygraph in trials. And I think the admonition would only serve the purpose to draw more attention to it. Where it is now is a throwaway line that is basically hearsay, because it was not part of the impeachment the Commonwealth was trying to elicit. And calling the jury's attention to it now would cause more damage, I think, than any remedy that the defense thinks it's due. So we would object to any admonition, and we're not agreeing to any stipulation.
And I remember Gallagher mentioning that he took a polygraph. He didn't say what the results were. That kind
Okay.
of blurted out.
I could, like I said, I didn't remember him saying that he had passed, and if he just mentioned that he took one, then
Bierman said, and both of those were not elicited by the Commonwealth. The witnesses just kind of regurgitated it out. Bierman was just giving kind of a narrative on his own about what Gallagher said. If there's any prejudice, I don't think it would affect the Commonwealth. I think it would affect us. If the jury thinks that Gallagher passed a polygraph, then they would probably think that he did not do the killing, because that would be the purpose of the polygraph. So I don't think an admonition is improper. Admonitions are often used when inadmissible, damaging, hurtful evidence comes in that shouldn't come in. All you would be doing is telling the jury what is in fact true, that any evidence that they heard about a polygraph examination is not to be given any weight or considered at all by them. And I know jurors are, I think for the most part they try to follow instructions and they do what they're supposed to do. I think there would be some jurors that would take that very seriously if it comes up in jury deliberations. I think somebody would say to the judge, so we're not supposed to consider that, and hopefully they would go along with that. I think they would give your words weight. So I would submit to the court, but I do think it's important. I think the party that's damaged is us, and it was not brought out by one of our witnesses. So I would submit.
I will give an admonition to the jury tomorrow morning that to the effect that they have heard testimony from one or more witnesses about polygraph tests, and that they're not to give that testimony any weight or consideration. I'll probably clean that up and I'll have it written down, and so I'll be able to read it verbatim, but I will grant that relief. Anything else?
No, I think that's it, Your Honor.
Okay, we'll resume tomorrow 9 o'clock with jury instructions, and
can we maybe plan on being in at
Early.
8:45, 8:30, 8:45, so we can do, and I think both sides are planning on using
Make sure
the technology.
works.
how about 8:30 we'll make the courtroom available.
Thank you.
Thank you.
Okay, see you tomorrow.
Thank you.
I don't know if they want me to take it back or not. Do you need to take it back, or? What do you want?
Yes, yeah.
Can you take it back, take the staple out? I can take
Want to
it.
give it to you?
Yeah, don't let anybody see me, so there. Thank you.
Yeah, I guess I'm gonna ask that she
Apparently the Monday issue was resolved, you know, about Monday.
It was, but with what Eric did, they were able to.
Did the Trinity people come and do anything to you? Because Eric stopped in to see if they could get in at lunchtime.